Meeting be in order. The chair would like to recognize the gentle lady from North Carolina, the vice chairman of the committee, or her designee. I see Virginia's not here. Recognize the gentleman from Utah for the purpose of motion.
Okay, Mr. Chairman, I move that the majority caucus of each subcommittee be constituted as follows. Subcommittee on Rules and Organization of the House, Mr. Nugent, Chairman, Mr. Bishop, Mr. Webster, Ms. Ross, Layton, and Mr. Sessions. The Subcommittee on Legislative and Budget Procedures, Mr. Udall as Chairman, Ms. Fox, Mr. Nugent, Mr. Webster, and Mr. Burgess.
Is there an objection to the request that's been made? Hearing none, so ordered. Thank you very much. And I would recognize the gentleman, the ranking member from New York, Ms. Slaughter.
Thank you, Mr. Chair. I move the minority caucus of the subcommittee of the Committee on Rules be constituted as follows. The Subcommittee on Rules and Organization of the House, chaired by Mr. McGovern, is the ranking member. I will be the member, and the Subcommittee on Legislative and Budget Process, Mr. Hastings is ranking member, and Mr. Polis as member.
Thank you very much. Is there any objection to the motion? Without objection, the motion is agreed to and so ordered, and I thank the gentleman very much. And I want to thank Mrs. Slaughter very much for working with us on the constituting of these subcommittees.
Indeed.
And look forward to each of our subcommittee chairmen and ranking members working well with each other, and I would expect that probably in a week or so you and I would sit down and want to talk about what we believe are some of the issues and some of the ideas which we would want to constitute within these subcommittees, as well as hearing from you appropriately about that. So we'll make sure we get that.
We would be pleased to do that. Thank you, Mr. Chairman.
Thank you very much, and I thank the gentlewoman. The committee today is being constituted for the purpose of hearing S.47 out of Judiciary, the Violence Against Women Reauthorization Act of 2013. And the chairman recognizes a member representing Judiciary Committee, the gentleman Trey Gowdy, the subcommittee chairman for Immigration and Border Security. And I'm delighted that you're here today. We're expecting the Honorable John Conyers, who would be representing the minority, and will move ahead at this time with consent from the ranking member at this time. Indeed. With Mr. Gowdy. I would like to give an opening statement, if I could, just for a second. Since its enactment in 1994, the Violence Against Women Act has been a vitally important tool for combating the epidemic that we have in this country of domestic violence and sexual assault that women face. Over the last 2 decades, Congress has acted a number of times to strengthen the provisions of this important bill and to make it more effective. We are here today to consider the effort so that we can continue to more effectively prevent and prosecute the crimes of domestic violence, dating violence, sexual assault, and stalking. According to the Centers for Disease Control, more than 24 people per minute are victims of these types of crimes in this country. That's more than 12 million victims each year. These were truly sobering facts that I have seen several times and know that they exist. And the statistics highlight the urgent need to reauthorize this important legislation. And while working with state and local authorities as well as civic institutions, together we all have a role in playing to diminish the level of violence against women. And this legislation has enabled the federal government to be more effective and to play its important role in this process as well. Under the House proposal, we will ensure that all victims have access to assistance and that no one faces discrimination. We also want to ensure that there is an automatic way in which the programs are implemented in an accountable way. And we want to ensure that tax dollars authorized by this proposal goes toward preventing and prosecuting crimes and assisting victims, not to wasteful or duplicative spending. While some of the details surrounding the issues have inspired a great deal of passion, and yes, they have, and spirited debate, certainly in this body and across the country, I believe that with this House proposal and what this Rules Committee will do will create a path forward. And this is an important time for us to take decisive action or against diminishing the threat of domestic violence and sexual violence in this country. And it is my hope that our hearing today will allow us to not only vet these issues, but see how this important legislation can be furthered through the United States House of Representatives. Does the gentlewoman from New York seek time?
Yes, sir. Thank you very much. I appreciate your letting me do that. This is a very important piece of legislation that we're dealing with today. As I mentioned to you before, Mr. Chairman, in 1994, our former colleague from Colorado, Pat Schroeder, and I were the authors of the original Violence Against Women Act. We never intended it at that time. It never occurred to us to discriminate against anybody. But we're worried that that is what we're talking about here today. A broad bipartisan coalition in the Senate sent us a comprehensive and a very inclusive bill. A broad bipartisan coalition, which includes most of the majority of the Republican Party, and all of the women in the Senate voted. I believe the vote was 78 to 22. Unlike the proposal here, the Senate bill provided strong protections for all the victims of domestic violence. And over 200 members of the House have co-sponsored legislation that mirrors the Senate-passed bill. And we know that 17 members of the Republican caucus have signed a letter calling for the inclusive and comprehensive bill to be presented to the House. With such a broad and bipartisan support for the Senate-passed language, which added important things to what we did in '94, it strengthened what happens on campuses with date rape. It made clear that the backlog of over 300,000 rape kits be examined for evidence and legal trials. And it strengthened what happens, just simply on what happens with date rape in campuses. And we were very pleased with what the Senate did and think that that encouraged the bill, made it much stronger. So we would like to finish with this time and not have to have this bill brought back another time. Since '94, the bill that we did reduced domestic violence by 67%. And what we did, based on research when we first did the bill, was that we knew statistically that most of the people who did abuse had been either abused themselves or had grown up in a home where it was happening. And so in order to change that cycle of abuse, we wanted to change the way we dealt with the issue. A lot of the money of the first tranches of what we did with the Violence Against Women Act was to train people in the police departments and the district attorney's offices and the judiciary on how to deal with it. For example, we made clear that when called to a domestic violence scene, it was not good enough to just go in and ask them not to do it anymore and then to have law enforcement go away and shut the door and have it start again, but that we needed to separate the victim and the perpetrator. These are the kinds of things that we've done, but if we can still continue to break that silence of abuse, but we've been over 500 days now without this bill and without this protection. I heard from a young girl today who was date raped on her campus, and to think that that is going on, and that, frankly, we all know the colleges and universities aren't happy to support it, talk about it. We need to give them the protection. But I also had an opportunity this summer to talk to people whose lives literally were saved by this bill. One young woman in my district who said she left home with a soldier, 17 years old, went to Colorado and mercilessly beaten and had no way to get any help until our office brought her home. The Army would not help her. Another who said that because of this bill, it saved her life, and not only that, but it saved her marriage. There's no reason for us not to have this bill. And the idea that we would discriminate against anyone in the United States who live within our borders, we couldn't turn our backs. I know we couldn't on people who are hurt and who are beaten up, and so we certainly shouldn't pass law that would do that. So this is very important today, and I think the one thing I want to make really bear down on, Mr. Chair, if I may, I think it's terribly important to us that we give the Senate bill an opportunity to have a clean up or down vote. and make a decision if that's the way we really want to go in America, by covering everybody. Thank you for the time.
Thank you very much, and I appreciate the comments from our ranking member.
Mr. Chair, I apologize. I spilled some water. I apologize for that. In my excitement over my agreement, my vehement agreement with the ranking member, I spilled some water.
There we go. We're going to clean up. Thank you very much. And that's right. We appreciate the feedback. I'm glad I didn't do it because I'm capable of that also. Mr. Gowdy, we've been advised that the gentlewoman from Texas, Ms. Jackson Lee, will be representing the minority today, and that she is on the floor but should be here in a few minutes. I would ask that, as always, the gentleman would offer testimony if he wishes to submit something for the record without objection. We'll accept that, and we'll accept the gentleman's comments. Gentleman's recognized.
Thank you, Mr. Chairman.
Wait just a second. We'd like to welcome you. We had pre-announced that you would be here, Ms. Jackson Lee, and feel free. We know that you'll be representing the ranking member, and without objection, I would like to ask you to come sit at the table as you choose, and then we will recognize you in just a minute. Gentleman's recognized.
Thank you, Mr. Chairman. Thank you, Ranking Member Slaughter. Thank you for the opportunity to testify before the Rules Committee today regarding S.47, the Violence Against Women Reauthorization Act of 2013. Mr. Chairman, the Violence Against Women Act was first enacted, as you noted, in 1994. It has since been reauthorized twice, including most recently in 2005. This legislation is important. It has been and should continue to be, and ideally will be this time, a bipartisan effort to protect the victims of domestic violence, dating violence, sexual assault, and stalking. Mr. Chairman, I know full well the toll these crimes take on the victims and their families. For many victims who survive, it's a life sentence of fear, a loss of innocence that time may mitigate but will never eliminate. And many of these cases are investigated and prosecuted at the state level, but we have also seen this is a national epidemic, and states such as my own have learned from other jurisdictions and implemented needed reforms through the help of grants like those contained within this bill. The House Substitute Amendment, Mr. Chairman, reauthorizes almost $700 million in funding for VAWA grant programs for 5 more years. It increases resources for sexual assault investigations, prosecutions, and victim services. This substitute makes certain these federal funds actually make it to the victims, service providers, and law enforcement agencies where it is desperately needed. There is additional coordination and oversight in the administration of the grants, and we are being good stewards of resources by making sure more of the money goes directly to the needs of the victims. Like the Senate version of S.47, the substitute amendment permits Indian tribes to exercise criminal jurisdiction over non-Indians who commit domestic violence crimes. This, Mr. Chairman, is a historic change to current law that should not be entered into lightly, but I have read the relevant case law from Oliphant to Laura and come to conclude that the House version meets the goal of reducing violence against women on tribal lands in a constitutional fashion that is most likely to withstand scrutiny in the appellate courts hereafter. It does no good. Indeed, it is harmful to pass any law that is likely to be reversed by the appellate courts of competent jurisdiction. Relitigating criminal cases after witness memories have faded, finding evidence that may have been lost or spoliated, does no one any good. So I cannot, in good faith, vote for any version of this bill that I know cannot withstand constitutional scrutiny at the appellate level. Moreover, the House version makes it clear with plain language that the constitutional provisions relied upon by defendants, victims, and law enforcement in U.S. District Court will be available in precisely the same measure to the same extent in cases prosecuted on tribal lands, something the Senate version does not do, Mr. Chairman. There's a ceremony each fall in my hometown, Mr. Chairman, where silhouettes are used to remember the lives of women and children lost to domestic violence. It is, as you might imagine, a tragically beautiful ceremony. There are purple balloons and there's green grass, and the voices of the living pay homage to those who have passed into the next life, usually at the hands of a senseless, horrific act of violence. I hope the committee will grant an appropriate rule that allows for the expeditious consideration of S.47. There are a few pieces of legislation, Mr. Chairman, that rise to the level of perfect. Indeed, the very document we swear to uphold and defend has been amended no less than 27 times. At a certain point, when lives hang in the balance, and they are all across the country, good has to be good enough. And I thank you for the opportunity to testify.
I appreciate the gentleman very much, not only his testimony, but the perfection by which he provided the content. And thank you very much. The gentleman is recognized.
I thank the Rules Committee, thank them for their courtesies on behalf of myself and Mr. Conyers. Mr. Conyers just finished, along with myself, on the floor in terms of a discussion on the Voting Rights Act. So I do thank you for your courtesies and your understanding. But this is a very important Rules Committee. I thank the ranking member for her leadership, without question. The Violence Against Women's Act must be reauthorized as soon as possible. When many of us travel to our districts, it is often that we are encountering women who have been abused or victims of domestic violence, or we may encounter even the various safe houses that are located in many of our communities. And their cry, and it is a cry, to ask for this reauthorization. It has frankly been too long. The prior reauthorization lapsed at the end of September 2011, 17 full months. The need for prompt action, however, does not justify, I believe, the present bill. The House that is now presenting this certain measure that falls well short of what is needed to ensure the effectiveness of this program. Let me allow good intent and as well concern. I think we all can allow that. The question is whether this initiative will be effective. The version of Senate 47 that should be considered is the one that best reflects the truly bipartisan measure that passed the Senate earlier this month, 78-22. What has happened with the present legislation is this is the House bill renamed by the Senate number, S.47. It does it only in name, not in substance. The Senate-passed version, S.47, includes long overdue protections against violence for immigrants, tribal members, as well as members of the LGBT community. The substitute language in S.47 now presented by the House does not meet standards, does not meet the toughness that is needed to protect these populations. The majority substitute amendment substantially weakens the Senate version's protections. I would argue that it is totally unacceptable. The majority substitute amendment strips protection for immigrants, tribal members, college students, Alaskan Native women, and members of the LGBT community against violence. I would make the point that despite, as I've just heard, the well-documented unacceptably high rates of domestic violence on tribal lands, the House substitute does not include adequate provisions to make it easier for Native American women to obtain orders of protection from abusers. I would simply say we owe it to those populations. They are our friends. They are Americans. Many of us have visited them on pueblos or reservations, and we know the needs of those communities. Many of you represent those communities. Certainly, a lot of us have had the privilege of interacting with Native Americans, no matter where we represent, and they are, in fact, contributors to this great nation. In addition, the House substitute drops the anti-discrimination provision that would ensure access to services for LGBT survivors of domestic violence, of sexual assault, stalking, and ensure access to services for them as relates to dating violence. Finally, the House bill eliminates specific protections for victims of violence on college campuses where we know high incidences of dating violence, sexual assault, and stalking occurs. I would argue that the statistics on women who fall to violence and ultimately die at the hands of an abuser are startling. Certainly, an incident that occurred in my own community caused me to have to attend the funeral of both the mother and the daughter. The daughter was 13 years old. And this person who was an abuser, this husband, this man who was an abuser, decided to punish both of them. And the difficulty, of course, is even local laws sometimes are not sufficient. That mother did not have a place at the time to escape to, and so it was easy for this individual to come back with a gun, which is maybe a dual-edged sword, and take the gun to the mother and the daughter, which caused this family to have a funeral of a young woman, a child, a teenager, and her mother. 2 precious lives lost. We need strong enforcement, and I would make the case that S.47 does not meet all of those 4 corners. I urge the committee to consider making in order an amendment co-authored by my colleagues and friends, which I hope to join, Representative Moore, Representative Slaughter, and John Conyers, that restores S.47 to the text of the original bipartisan Senate bill. I believe the lives of American women and American children owed this kind of commitment, and I'd ask my colleagues to consider the amendment and ask my colleagues to consider opposition on the present underlying bill before the Rules Committee. I thank you very much for the time.
Thank you very much. Without objection, we'll accept any written statement that the gentlewoman prepared for the committee. Thank you very much. Mr. Gowdy, I have one question. There are programs which were under this umbrella of the legislation, even though it has not been reauthorized. Are those programs today being funded?
Yes, sir.
They are being funded.
They are, and quite candidly, Mr. Chairman, Lynn Hawkins, who runs the Safe Homes Rate Crisis in my hometown of Spartanburg, has done a phenomenal job. They're obviously worried because I don't want to misstate anything to the Chairman. They want it reauthorized, but in terms of there being a stop in service or function, there has been none.
Good. Thank you very much. The gentleman, Mr. Cole. Ms. Slaughter.
Thank you, Mr. Chairman. I do want, you're absolutely right, there's still some money on which they're operating, but I just got the word today that sequestration will take $20 million away from the money that's left, and if this is not reauthorized, that money will go very quickly. And I'd like to ask unanimous consent to insert a statement of the administration policy on this bill and read from it. The administration supports the measures in the House bill to reduce domestic violence, homicides, and provide resources to states to address rape and sexual assault, and recognizes the bill does not include some of the harmful rollbacks in victim protection contained in the version passed by the House in the 112th Congress, but the administration cannot support the House substitute to S.47 as currently drafted. The bill fails to include critical improvements passed by a large bipartisan margin in the Senate that will continue the progress the nation has made in combating the violence against women. It omits the crucial provisions to address the high rates of violence experienced by young women on college campuses. The Senate bill requires colleges and universities to provide information, which is very important since they don't often do that voluntarily. They have to provide the information to students about dating, violence, and sexual assault, and develop the policies that improve reporting, investigation, services for victims of these crimes, and every parent who has sent a child off to college knows the importance of these common sense measures to keep young people safe. The House bill would also inhibit the successful prosecution by tribal authorities of non-Indian perpetrators of domestic violence. The proposal as currently drafted would continue to allow for disparate treatment of Indian and non-Indian offenders and fails to adequately address serious criminal violations of domestic violence in tribal communities. The administration urges the House to adopt the Senate language recognizing tribal criminal jurisdiction in domestic violence cases. The administration is disappointed the House bill does not require covered housing programs to implement the emergency transfer plans for the victims of domestic violence who have to be housed elsewhere and sexual assault, and does not explicitly protect LGBT victims of crime from discrimination when they seek the services or protection funded by VAWA. Unfortunately, the House measure also does not reauthorize the Trafficking Victims Protection Act in the Senate bill, which provides critical protections and services for the victims of modern-day slavery. The administration urges the House to fulfill its commitment to reauthorize VAWA by scheduling a vote on the bipartisan version of S.47 that overwhelmingly, as I said, 78-22, passed the Senate, championed by both Democrats and Republicans. And the leadership on our side, Mr. Chairman, has indicated failure to allow an up or down vote on that they will not be able to support the bill as it's being presented today. Thank you very much. No questions.
Thank you very much. Mr. Woodall?
Thank you, Mr. Chairman. I listened with interest as the ranking member talked about the origin of VAWA back in 1994 and the real heavy lifting that had to take place then to bring so many communities up to speed, and apparently a lift that the gentleman from South Carolina has seen successfully implemented back home. We talk a lot about sunsetting legislation, and we have a reauthorization process so that we will go back and look and see how to do things better. I'd like to ask the two of you, how will we ultimately measure success here? I mean, there's no question from what you both have said that you've seen the real life impacts that these dollars have had, the lives that have been protected, the lives that have been improved. Will there come a day in our lifetime that we're going to sunset VAWA and say a job well done? Or in each reauthorization period, will we be looking at new and different populations, at new and different situations that had not presented themselves before, and continue to expand that mission and impact more communities?
Well, that's a great question, Congressman. The answer, unfortunately, depends upon whether or not the human condition evolves or not. And I have not seen it evolve a whole lot. I didn't in my prior job. I will say this. There was a time in South Carolina when state legislators belittled domestic violence, told jokes about it. That's not the South Carolina of today. There was a time when women had to fend for themselves in magistrates' court because we wouldn't even appoint prosecutors. The perpetrator had a lawyer, but the victim didn't have a lawyer. The first domestic violence case I was ever involved with, a lady was beaten with the buckle of a belt, and law enforcement did not even secure the belt as evidence. That would never happen in a homicide case. It never happened in a burglary case. I cannot overstate the progress that has been made in my state. That's the one I know. The penalties have been increased. The services have been provided. The homicide rate has gone down. There were 2 years, Congressman, where we had 0 women killed at the hands of men who claimed to love them. And I'm going to focus on men killing women. I understand that that's a point of contention. I never prosecuted a woman for killing a man, not in 16 years. I stopped counting at 80 the women that I prosecuted, the men that I prosecuted for killing or raping women. So we're making progress. Are we ever going to get to the point where we come in and say we don't need it anymore? Is the human condition going to evolve to that point? Probably not in our lifetime.
So whenever Congress passed legislation that is punitive, that speaks to the ills of society, the higher angels always hope that change will come. But I think Mr. Gowdy has made a very potent statement, and I'd like to just put some statistics in the record because I answer the question in a dual fashion because you asked about changing populations. Just as for the record to note, 34% of American Indian and Alaska Native women will be raped in their lifetimes. 39% will be subjected to domestic violence in their lifetimes. 67% of Native women victims of rape and sexual assault report that their assailants are non-Native Native individuals. And on some reservations, Native women are murdered at more than 10 times the national average. And the circumstances may vary. But what I would argue is that we're going to get better at prosecution. We're going to get better at intervention. I think that is key. Because the incident that I reported on the mother and daughter, they had been out of the home. In that moment of him leaving, getting a weapon, and coming back, that might have been a moment to save lives and even to alter his life. So I would make the statement that this legislation will be needed as long as we find circumstances where women are vulnerable. And you see this is expanding to another population of LGBT in terms of the language that we're supporting, but in any event, and populations may come in, immigrant populations, documented immigrants, who have a language issue, refugee women, I encounter them, all face circumstances where they may be abused. I do believe that we have an opportunity for outcomes. I indicated to you I was debating on the floor of the House the Voting Rights Act, and many have different views about that. But I do believe that we have the ability to assess outcomes, and the question will be whether those outcomes will ever reach a point where we will say that we have reached our ultimate goal. But there's no sin to determining, as Mr. Gowdy has said, whether we've been making some progress, whether or not there are less of these cases, and again, whether or not there is the intervention. I'm a big believer in the intervention. I'd rather have a woman in a safe house, a women's shelter. I'd rather have training to go on to help with the outcomes than the constant prosecution. But as it speaks now, in the current 2013 life that we lead, I do think that this is a very vital piece of legislation.
We just doubled the size of our women's shelter. In my largest county, there is no shortage of applicants for those beds, sadly enough. I thank you both for your work.
Thank you.
Thank you, Mr. Chairman. I just want to say that I associate myself with the remarks of our ranking member, Ms. Slaughter, and the remarks of Ms. Jackson-Lee. I think for some of us, this bill does not adequately protect the most vulnerable victims of violence, including the LGBT community, immigrants, and Native Americans. That's our view. I also wanted to express a little bit of frustration because, not everything has to be a fight. And the Senate, by a vote of 78 to 22, passed a bill, the reauthorization bill. Some of the most impeccably conservative members of the Senate voted for that bill. And I guess I would say sometimes it's okay to say yes and move on. And I was kind of hoping that this would be one of those areas where we can kind of come to some sort of bipartisan agreement and be able to get something done and move on. And the more we can get done together, maybe the more we can build on that relationship and maybe solve our budgetary problems. But I do regret the fact that what is coming before us today is something that I think many of us find totally unacceptable. It doesn't represent the bipartisanship that was in the Senate. And if my friends don't want to say yes, they ought to at least give us the opportunity to vote up or down on the Senate bill separately and bring that to the floor and see where it goes. So, I appreciate both my colleagues testifying, but the bill as it is written to me is a big disappointment. I thank the gentleman.
Thank you very much. Mr. Nugent? Not seeing time. Mr. Hastings?
Thank you very much, Mr. Chairman. Mr. Gowdy, when S.47 was passed, it was passed overwhelmingly in the Senate, and it's my belief that this particular measure will not be accepted by the Senate because of the things that Ms. Slaughter, Mr. McGovern, Ms. Jackson-Lee have pointed out, and that's largely that it leaves out protection for some very vulnerable people in our society. Let me start with the immigrants as a for example, and the significant number of people that are involved in trafficking of women and children. One of the leaders in this Congress on that subject worldwide is a colleague of mine and yours, Chris Smith from New Jersey. I would be interested in how he's going to vote on this measure in light of us leaving that part out that the Senate had put in. The same thing holds for Native Americans. And equally, the concerns for lesbians, gays, bisexual, and transgendered people who are left out of this particular measure that the Senate had put in. My question to you is, why were they left out? Was it because of the cost, or is it because there are some in the majority who feel that these vulnerable people in our society are not deserving of the protection under VAWA?
Well, Congressman, I would provide you a third option, which is that the House version does protect exactly the same groups that it has been contended today or not. protected. It never ceases to amaze me, no matter how many times a false statement is uttered, it does not make it true. I am looking at language in the House version. No person in any state shall, on the basis of actual or perceived race, color, religion, national origin, sex, or disability be denied the assistance or excluded from receiving services from a grantee under any program or activity. I don't know how it could be any clearer. I don't know what category of species is left out of no person shall, on the basis of actual or perceived race, color, religion, national origin, sex, or disability. That covers everyone. So the notion that someone is being discriminated against, and I'm going to skip over the historic, I'm going to skip over the notion that this initially was a Violence Against Women Act. This House language also allows for the prosecution of interpersonal violence that is man on man and woman on woman. That also is in the House version. It's also in the House version that the Attorney General can promulgate rules to make sure that there is no discrimination. So I guess, the politics of wanting 4 letters in the bill, but the truth is there's no one that's not protected, and it's a red herring.
All right, the gentleman from, I'll yield to the gentleman.
Yeah, I mean, the gentleman mentioned that this applies to everybody. However, is there anything in there that would prevent a shelter that's receiving VAWA funding from turning away a battered woman when they ask her who her abuser is and they say it's another woman? Is there anything in this bill that would prevent a shelter from turning away that woman?
No person shall, on the basis of actual or perceived race, color, religion, national origin, sex, or disability, deny the existence.
But that would be based on sexual orientation, would it not? It's not based on those other categories that you mentioned.
Well, the Attorney General is welcome to promulgate rules to enforce that. I've never, in 16 years, heard of someone being turned away for the reasons that the gentleman cited. And if there's a concern that there is, the Attorney General is welcome to promulgate a rule to absolutely clean that up.
I mean, I understand in your experience you've never heard of women meeting up men in relationships.
No, I've heard of it. I've heard of it. I said I've never prosecuted a woman for killing a man. I've heard of it.
Okay. And have you prosecuted women for domestic abuse of men? Short of killing, of course.
Some.
Okay.
But also, it would be disingenuous for me not to say this. 99% of the time, it is a man abusing a woman. So I'm happy to take care of the other 1%. I don't like violence, period. I prosecuted a man for killing his intimate partner who was also a man in South Carolina. I don't like violence no matter who's perpetrating it against anyone.
I'll go back to Mr. Hastings.
All right. Mr. Gowdy, I practiced law too. And I practiced it in an era before F. Lee Bailey had the success in the battered wife syndrome. And I did represent 13 women that killed men, and I won every one of those cases, be they first-degree murder or second-degree murder, and the one manslaughter case among that 13. It's one of the proudest records that I have. And I was trying the battered syndrome or wife syndrome without knowing that I was. And that's why I was successful. I also represented 16 men that killed women. I lost 15 of the 16 of them. The point that I'm trying to make to you is this violence continues, and the areas that you say are covered with that simple language, obviously the administration takes exception. For example, the language that was read into the record by my good friend, the ranking member, where the administration says, the bill omits crucial provisions that would address the high rates of violence experienced by young women on college campuses. You take the position that that statement is in error because the language that you read from the bill covers that?
Well, no, I think that's a separate issue, and if my colleague would indulge me, I'll get you an answer on that. I can't speak to that provision. I wasn't trying to cover everything with that language. If you'll give me a second,
I appreciate it.
I will.
All right.
I think I can explain perhaps two of my colleague's questions. My colleague also made reference to Trafficking Victims Protection Act. The Clery Act, if I have it right, both of those are standalone provisions. I think Senator Leahy added the Human Trafficking Act in the Senate. There is no opposition to the act you just made reference to or to this Human Trafficking Act. I think the opposition is the manner in which it was attached to the bill. E&W would like the Clery Act to go through regular order in E&W, and I think Judiciary would like the Human Trafficking Act to go through. So that may not be a fully satisfactory answer. It is not an opposition to the underlying principles. It is an opposition to the manner in which they were included or excluded.
May I?
Ms. Jackson-Lee, I was wanting to complete a thought, and that is that it appears to me when we vote on this matter that is entitled the Violence Against Women Reauthorization Act, that rather than do as Mr. McGovern said, come together and since the Senate overwhelmingly passed the measure, just run S.47 through here and send it to the President to sign it. But somewhere along the line, politics enters into the picture. So when I vote against it tomorrow, but for the fact that every human rights organization and others that have contacted my office all have said that they oppose it, the general public may not get that. And so what it will look like politically is that I voted against the Violence Against Women's Act. But I did so and will do so for the reason that it is not inclusive. I accept the fact of what you said about the language. Ms. Jackson-Lee, you were about to make a point.
Well, I think to follow your thought, what is missing here is that this bill is not comprehensive. And it is very difficult. Mr. Gowdy is a former prosecutor, and I have served in a capacity as a municipal court judge and had to be a decider of facts. And one of the things that always helps, no matter what level of law you're dealing with, is a precise understanding of what is a violation. And so in the litany that Mr. Gowdy read, sex is not sexual orientation or gender. And these are some of the issues that we're speaking of. The other provision or concern is, I think, as I was listening to Mr. Gowdy's concern about language that might not stand muster on appeal. And I think that language he was speaking of dealt with criminal jurisdiction questions, which have been watered down in this form of S.47. Those same provisions have been vetted by the Justice Department before they were submitted in the original bill in 2012, S.1925. And the criminal jurisdiction, this is dealing with Native Americans, the criminal jurisdiction is not broad-based, so it may have been he was speaking of something different, but I want to get this on the record. The criminal jurisdiction that ensues is a special domestic criminal jurisdiction, so it's not broad-based. And one of the things that was noted as I was giving you these large numbers is the numbers of U.S. attorneys. Now, Mr. Gowdy, I'm not sure what level of Native American prosecutions he may have had, but refuse at the present law, the way the law is now structured as it relates to Native American women, to prosecute those cases. That aspect is missing out of this underlying bill. That's a very important component, as is the issue dealing with college campuses. That is a whole other story altogether. So I think the word that I'd like to leave the Rules Committee with is that it's not comprehensive, and it would be better to use the original S.47 so that this could be comprehensive legislation.
Well, certainly legislation is needed. Borrowing from my friend from Georgia who commented that the shelter in his area has increased. I'm an original board member of an organization in my county called Women in Distress that was founded in 1966. And that organization continues, and as Mr. Woodall pointed out, availability of space is not the kind of thing that would allow for every woman who is pummeled by some fool to have an opportunity to go just to the women in distress as one shelter. And there are others that have come up over time. We need to do the right thing, and the right thing is to pass, as Ms. Jackson-Lee said, a comprehensive measure and stop the partisan politics. I can handle it, and everybody here can handle it, but we know that we are not doing everything that is necessary to protect the vulnerable people in our society. Thank you, Mr. Chairman.
Thank you very much. Mr. Webster? No, not seeking time. Mr. Bowles.
It's my understanding, and I think this is what I'd started by asking before, but I'll frame this again for Mr. Gowdy, that the bill in its current form does it do anything to prevent a shelter that receives VAWA funding from turning away a woman because the person that battered her is a woman instead of a man? Is there anything that prevents that from occurring in the bill?
I just, with respect, read the language differently than you do. I don't think anyone can be discriminated against that claims to be a victim of interpersonal violence.
Well, with those categories, I mean, she's not being discriminated against because of her sex. She is a woman. She's being discriminated against because of the sex of the person that battered her, and that's a matter of sexual orientation.
All I have is 16 years of everyday experience. Most shelters aren't particularly interested in the politics, the gender, anything else of the perpetrator. They're trying to find a safe place for someone who is a victim of interpersonal violence. And I think the language is sufficient. And reasonable minds, I guess, can differ on that. I just reject the notion that I've heard that we're doing nothing to protect all these large groups. There's a long series of qualifications and characteristics that cannot be discriminated against. You may, in good faith, take the position that it doesn't include everything that should. If you take that position, the Attorney General has the ability, which is the very next section, to promulgate rules to make sure there is no discrimination.
Again, we're dealing with law, obviously, and we're dealing with federal support for nonprofits and public agencies under VAWA. It's an entirely different matter than what private agencies decide in regards to who they may or may not serve if they're entirely privately funded. The differences with the Senate bill in this regard is the House bill removes the gender identity and sexual orientation from the list of non-discrimination categories that you mentioned, which would eliminate a requirement that all programs and activities that receive VAWA funding provide services to victims regardless of their sexual orientation or gender identity. You're saying many do. I don't deny that. I'm sure that many do. I think within this body I would argue that if you are to receive federal funds under VAWA, it's not a matter of saying we might. It's a matter of saying you must serve, particularly a traditionally underserved population, which gets me to the second failing of the House bill, which fails to include the LGBT population in the STOP grant program, which is the largest program supporting law enforcement, prosecution, and court and victim services. And then finally, eliminating the definition of gender identity and sexual orientation from underserved populations, thereby blocking funding from service providers who do outreach in the LGBT community, a population that certainly faces barriers to care. And again, it's not a matter of what one thinks of particular actions or particular ways people live their lives. The outreach is absolutely critical in all of our communities, particularly underserved communities, immigrant communities, the gay community, the Native American community. I think has been indicated by our ranking member and others, there's a clear way forward on this bill. There is a strong VAWA reauthorization that has received strong bipartisan support that I feel confident in saying would pass this House, would pass this body if it were brought to the floor. And instead, we are presented with a controversial bill where no controversy need exist. The fact that we would even have this discussion, well, most don't turn them away, some might, I don't think they do. Well, why not have that certainty so that women are not turned away, particularly women who have some of that, the at-risk criteria. I mean, I might ask, what are the reasons, those three things I mentioned, why are they stripped from the House bill? I mean, they seem non-controversial, outreach to at-risk, and including LGBT in the STOP grant, making sure that grantees don't say no to women just because of their sexual orientation. I mean, if, at the very least from your argument, it sounds like you feel that they might be redundant because it's already the case. So why not include them just to give everybody the assurance that, in fact, we do mean all women?
Two things. I stand to be corrected. I think with the STOP grant language, it has been changed. It was changed from the last reauthorization. Actually, may have been changed from 112th Congress, violent crimes that predominantly affect women. That represents a change in the language in this version versus the last one. You mentioned the word certitude. I like the word certitude. And I have heard glowing assessments of the Senate version as if it is, by the way, there were lots of amendments that were offered, and the vote wasn't 77 to 22. That's the nature of having a majority. At some point, you get the bill you want, and you either vote up or down on it. And they're in the majority in the Senate. I can just tell you this, if you like certitude, if you like certainty, you will not like the tribal constitutional language in the Senate version. It is going to be reversed on appeal. Now, we can prosecute as many cases as we want and send as many people to jail and hire as many lawyers as we want to do the habeas review. It's going to be reversed under Oliphant, Dura, and Laura. So I would be careful lauding the Senate bill too much. Certitude can also include the certitude of being reversed.
Again, I think that I would clarify that if there's ideas to provide more certitude in the House version, there might be bipartisan support for some sort of amendment to the Senate bill that provides more certitude. But these proposed changes that we've gone over here today provide less certitude and certainly move the bill in that direction, which is why I oppose the bill and hope that we can at least allow an open rule to allow the House to work its will. And I'll yield back the balance of my time.
Thank you very much. Mr. Burgess, Dr. Burgess.
Thank you, Mr. Chairman. Mr. Gowdy, maybe you can help me just a little bit here. The Chairman already asked you about the funding. With the expiration of the current Violence Against Women Act, you said the funding was continuing. Did I understand that correctly?
Yes, sir, Doctor.
What about prosecutions? In the 17 months that the authorization has lapsed, are we letting people go who should be prosecuted under the law? Are we not prosecuting criminals who should be prosecuted?
I've heard no stories in South Carolina or anywhere else that people are avoiding prosecution, apprehension, investigation because there has been a hiccup in the reauthorization. My understanding is the funding has continued. I can promise you the prosecutions have continued.
Well, I guess what I'm having difficulty contemplating is that were all cases prosecuted prior to the expiration of the authorization? Was there a case, perhaps a famous case at Notre Dame University that wasn't pursued in August of 2010 when the law was in effect? Could that have happened?
I may not, and it's my fault, not yours. I may not understand the question.
Well, there was a very famous case at Notre Dame in August of 2010. The Violence Against Women Act was in complete effect at that point, and as my understanding, that case has never been resolved. So the only point I'm making is even with the protection of the Violence Against Women Act in full throttle.
There are so few, if any, bona fide criminal provisions in VAWA. Anyone who is using the lack of a reauthorization to justify a non-prosecution is wrong. I may have found one bona fide criminal provision. So what was against the law prior to our lapse in VAWA funding has always been against the law. So whether it's rape, whether it's stalking, whether it's domestic violence, this hiccup in reauthorization should not affect anyone's prosecution. So I'd be curious who is blaming this for not pursuing a case.
Just to be clear, I don't know that anyone is blaming this. The point I was trying to make is even with the full effect of the Violence Against Women Act, the world was not a perfect place. And
That is
errors
true.
did occur.
If the gentleman would yield just
Yeah,
for a
we have to
second.
yield to the sheriff.
Most of the prosecutions for domestic violence are state over federal. In 38 years, I don't recall a single federal case being brought on domestic violence. But I will tell you that in my 38 years, it has changed, and I think you mentioned it. When I first started out as a cop outside of Chicago, cops would go into a domestic violence situation and separate the parties, ask them not to hurt each other, and leave. And in those 38 years, things have changed dramatically in regards to how law enforcement deals with domestic violence. When I was sheriff, it was a zero tolerance. Somebody was going to go to jail, is simply put. But what's happened over the years is with domestic violence courts, Ms. Jackson Lee's, was probably one of the best things that ever happened to the criminal justice system, because it forced the abuser to get the help they needed so they would not re-abuse. Domestic violence cases are probably some of the most difficult cases to prosecute. I'm sure you'll agree, because a lot of times you have a reluctant witness. While they may want to prosecute at the time of occurrence, for whatever reason, they're in love, they decide not to, or it's their only source of income, they decide not to. And I sat on domestic violence board, domestic violence shelter for 20 plus years as an advocate. And it is a huge problem throughout the United States. But I will agree with you on one thing, that with the aggressiveness that law enforcement has taken because of statutes because of dictates from the federal government, but statutes, we arrested women on violence against men, women on violence against women, men on men, and men against women, of course. It was never a question in regards to who was going to go to jail because of what they did as related to domestic violence. And the biggest losers on all of this are the kids. The shelter that I'm familiar with in the Dawn Center in Spring Hill, Florida, that we have so many children in the center because typically when a woman leaves, goes to shelter, they bring their children. But one of the things the shelter had problems with is, what do you do with a man-on-man? And so the way the shelter would deal with that, because they didn't have bed space available within the shelter for a male, they would rent a hotel room to put that person up in to get them away from the violence. They were never turned away. It was never an issue, whether if a perpetrator was a male or a female, or if it was same-sex on same-sex. That was never the issue. The issue always was it domestic violence? And so I appreciate what you're doing here in regards to moving this forward, but you're correct. It never stopped a single prosecution with this lapsing. It stops the dollars because typically those dollars are not passed directly to the shelter, they're passed through the state to the shelter. And if you read the rule, it has to go through DOJ, and DOJ sets the parameters in regards to what happens with those dollars when the state receives them to hand those out to the shelters. And it's the DOJ regulations that set the standard. So I yield back. Thank you, sir.
And I thank the gentleman for his clarification. The only point I was trying to make is that, to the best that I can understand, there are not vulnerable populations who have been harmed. I believe the reauthorization of this statute is important, and I hope that we can indeed get the work done and get it taken care of. But it is, I don't think there are people who are presently being harmed by the fact that this has not been reauthorized. It's important work. We need to do it. But, Mr. Chairman, I'll yield back.
Thank you very much. Mr. Cole.
Thank you, Mr. Chairman. I hadn't intended to enter in, but I want to disagree with my good friend, and you are my good friend, and I admire you as a litigator, and frankly, I know how much more you know about the law than I do. There's no question. Having said that, just for the record, I disagree very much with your contention on the constitutionality of tribal jurisdiction. And I want to ask a couple of questions in that regard. First, I have an amendment that under consideration that would allow non-Native Americans to opt out, go directly to federal court. As you know, one of the great problems you have in Indian country is the jurisdiction is federal. We don't have nearly enough law enforcement officials. We don't have nearly enough prosecutors. Quite often the distance from a U.S. Attorney's office to a reservation is vast. So these cases just simply go unprosecuted, and quite often because they are so often unreported even. So the problem is horrific. If a non-native could opt directly into the federal court, would that mitigate your constitutional concern?
Getting closer. Getting closer.
I'm trying to get close to you. Legally.
Yes. No, I think, I was not making reference to you and Chairman Issa and your amendment as much as, the Senate says whatever constitutional safeguards are necessary. I want all my constitutional safeguards, whether somebody thinks they're necessary or not. So I was actually critiquing the Senate version much more so than I thought you made a really thoughtful presentation, you and Chairman Issa, yesterday. The opt-out, will it survive Oliphant, Dura scrutiny? That's the challenge. We won't know. I'll also say this, though. A 50% dismissal rate and a 67% dismissal rate in sex assault cases is totally unacceptable. And at some point, I understand there's a distance to drive. I get that. Lots of y'all's congressional districts have a distance to drive. Those dismissal rates are so abysmal, at some point, some U.S. attorney is going to have to explain for it. Either they're making bad cases or they're dropping good cases, one or the other.
Well, and I want to posit for the record, number one, I appreciate how much the majority leader worked to try and move this, the Republican alternative, if you will, in the right direction. And it's considerably different, better, and stronger than was the case when we considered this legislation in the previous Congress. So I know there's been a genuine effort and a genuine recognition of the problem. Let me ask you a couple other questions, if I may. Do any National Congress of the American Indians, any tribes, any tribal law enforcement officials prefer the Republican alternative to the Senate bill?
If they are, I am not aware of it. And I think I'm not aware of it because there aren't.
Yeah, and so while I posit that we're trying to do the right thing, when the people you're trying to help don't think it's working, probably ought to listen to them. I want to ask the gentlelady, if I may, does the Senate bill have the support of National Congress of American Indians, Indian law enforcement people, tribal tribes, what have you?
There are a series of endorsees, and to my knowledge, I'm just trying to find the letters. To my knowledge, yes, they have a vast amount of support, and I'm glad you've asked me if I might just expand on your inquiry and also expand with respect to the term that I want to use. The reason why we do this federally, there is a lot of state prosecutions, Mr. Gowdy, as he well knows, is because dictates from the federal law have far-reaching impact in terms of the grant funding that ultimately is used, clarification of the grant funding, and in Native American circumstances, which I think is crucial, the concept is equal protection. That's what a federal law will then give, because you do govern the federal oversight or the nexus between our relationship with the tribes. You well know, Mr. Cole, I'm already speaking to someone who's quite well experienced, is a federal nexus. We need that equal protection of the law, and I want to put on the record again, 52% of violent crimes that occur in the Indian country are not prosecuted. 67% of cases decline were sexual abuse related cases. What we're missing in the bill before us today, and we did not accept the Senate version, which I'm arguing again enthusiastically to allow that up or down vote for the Moore, Slaughter, John Conyers amendment, is what we have today is that we're eliminating the opportunity just in the domestic instance to allow those non-Indian men or persons to be prosecuted under the tribal system, because in most cases, both the state and the federal don't take the case. So the underlying bill, even though I appreciate all who tried to make this one strong and name it S.47, the original S.47 gave that kind of strength and narrowed the jurisdiction. So I would just say this to Mr. Gowdy's point about failing to, on a number of occasions, about failing to succeed on appeal. We well know that the courts, even though there's precedent, look to the legislature to correct what may be an error and would respect that legislative process, the legislative history, the reason why we decided to correct what had been stated case law. So we've written a statute to correct it or to improve it. This is what this legislation is. And if I might conclude on something that you might not have inquired of, but I think, Mr. Chairman, if you indulge me for a clarification, and that is on the LGBT that I think Mr. Polis was rendering or trying to raise a question on. It's not a question of gender. It's a question of, and I think Mr. Gowdy said it'll be answered by the regulatory structure, but it's a question of how in the intervention, in the services, you've got a vast nation. And so the question is, if I'm in an area in parts of Texas and I am in the LGBT community and I seek intervention and it's grants, there needs to be the federal presence law that embraces equal protection of the law, that says that you need to be equipped, Women's Center, for that person, and you need to receive the services that person needs to receive the services.
If I may ask a question to both of you, and correct me if I'm wrong, is my understanding, and again, I'm not an attorney, both of you are distinguished attorneys, that the Indian Civil Rights Act of 1964 guaranteed anyone who appears in a tribal court all the constitutional protections that any American citizen enjoys. Is that correct? Not correct or incorrect?
Is there a statutory maximum of 1 year for those offenses? I stand.
Actually, it's now 3 years with the Tribal Law and Order Bill that was passed 2 Congresses ago.
And so that act gives the full panoply of all constitutional rights? That's
my understanding. I was just asking if either of you happen to know.
I think you're going to the point of redundancy and whether or not it's already covered.
I would agree with the gentlelady from Texas, but sometimes you got to be redundant to make a point.
And I'd make the argument that as you asked the question, it would cause us to do the research, but I think the tying it to the legislation that is now unique, which means that we're trying to change a breadth of jurisdiction, meaning to embrace a non-native American under that tribal court just for that issue, we might need the reciting of this distinction again, because that is an action that is distinctly unique. It makes an equal protection argument, but it is an action that is unique, and I think it needs to be recited in federal law.
Yeah, well, let me make a point, and then I'll certainly yield back my time, Mr. Chairman. You know, currently in the Congress of the United States, if 535 of us went on the Navajo reservation and committed a crime, 2 of us would be subject to local jurisdiction. I would be subject to the local jurisdiction. My friend Mark Wayne Mullen, who's an enrolled member of the Cherokee Nation, would be subject. Nobody else would be. Now, I wouldn't go into any other community. If I went to Alabama or I went to Texas and I committed a crime, I would expect to be, dealt with by that justice system. I'd be arrested by a Texas cop in a heartbeat, I'm sure, Mr. Chairman, if I was in an OU T-shirt.
Only if we get half a chance.
Yeah.
That's normally after the Oklahoma-Texas game.
Very good analysis.
Texas is a very dangerous place for any of us to be in October if you're on my side of the Red River. But, that would, and I'd be subject to that jurisdiction, but I would have all my constitutional rights, too. If there was some constitutional abuse, I would have the ability to appeal. And the only place that I'm aware of that we don't do that is in, in Native American nations, in reservations, where they do not have the ability to police their own communities and protect them. I think sometimes, and I know this is not the case with Mr. Gowdy or most people, because believe me, I know how hard people have worked to try and find a solution to what's a thorny jurisdictional problem. But it's as if some people are concerned that somehow they're going to be treated unjustly in a tribal court to make up for 500 years of difficulty in the relationship between the European population and the Indian population. I can assure you that's not the case. I mean, again, if people are willing to trust me, put me at jeopardy of that, then they ought to be willing to put other people. And at the end of the day, allowing tribal courts to exercise policing power and jurisdictional authority to protect their own citizens is actually the best way to solve the problem. I think we moved a good way in the right direction in the Republican bill. I like my amendment a lot, Mr. Ice's bill, really. But the Senate language moves in the right direction, too. And, again, does have overwhelming tribal support, and they can get a stack of lawyers and constitutional experts that would argue it does pass constitutional muster. That's always an interesting debate, and it has real-life consequences, as you correctly point out, because if we lost a lot of prosecutions, then, we would have done something. So I appreciate, honestly, the discussion. But at the end of the day, we know what is out there now isn't working very well. And there's some pretty smart attorneys in the United States Senate, too, and a lot of them thought this met constitutional muster. I think they take their constitutional duties as much as we do. And while I tend to disagree with the President on many issues, he is a constitutional scholar. He knows something about this area, too, and he's expressed his strong support. And I know on Native American issues he's done a terrific job. He and I disagree on about 95% of the time, but 5% he gets really right. I think this is one of those ones where he is. But, again, I appreciate the effort, and I want to make this abundantly clear. I really appreciate the effort because this is an area that a lot of people don't know a lot about. Most people don't have the opportunity. There's not, not tribal jurisdictions in a lot of the country anymore. I think a real effort has been made on both sides of the aisle here. These are much more robust sections than we've ever had before, and so I appreciate that. And there's also, there's significant Republican support both for my amendment and, honestly, for the language, the underlying language on Native American issues in the Senate bill. So I waxed a long time. I certainly want to give you an opportunity if you wanted to.
No, sir. I wanted. You asked me about tribal leader support for the House version, and I drew a blank, and that blank still exists. It may be the seventh sign of the apocalypse for me to cite the National Association of Criminal Defense Lawyers and the National Association of Federal Public Defenders, but both of those groups have signed a letter saying that the House version passes constitutional muster in a way that they believe is most appropriate. That was not directly in response to your question, but I wanted to at least be fair to these two entities that they think the House version passes muster in the most constitutionally protective way.
Well, I think that's an excellent and a more than fair point to make, but I do go back, again, when we're dealing with groups and we're trying to extend protections to hitherto underprotected, underserved communities, we ought to listen to what they have to say. And they not only support the Senate bill, they support the ISA bill. They said either one of these are acceptable to us. So I don't consider this a partisan debate or dispute. They found both a Democratic solution and a Republican solution. And as my good friend, the gentlelady from Texas, pointed out, while there was considerable controversy over this provision in the Senate bill, and as they worked their way through the legislative process, point that you made, majorities get to, at the end, vote on what they want to. Over half of our colleagues did vote for this bill and did find the Indian provisions not to be so objectionable that they would sink the whole bill. So just a point worth making. Mr. Chairman, you've been incredibly generous with your time and indulgent. I appreciate it. I yield back.
I thank the gentleman and also would like to thank him and anyone else on this committee that has taken the time. I know I've spent a lot of time. I know Mrs. Slaughter has taken time, and I know the gentleman, Mr. Cole, has taken a lot of time to not only represent this community, but also, or this committee, but also the community of interest that they may have back home, interests that are very important to them. And so I want to thank the committee members who have invested time in that. And I want to also thank both of you who have taken time to be here today. I respect and appreciate your comments that you've made today, and I want to thank you. Seeing no further questions, both of you.
Chairman, may I ask for unanimous consent to add Mr. Conyers' statement into the record?
Without objection.
And respectfully ask for an up or down vote on the amendment, as I indicated before, of the three co-sponsors on the substitute for a comprehensive approach. I thank you for your courtesies, and I hope that I made the explanation clear on the narrow exception to protect the Native Americans and to protect the LGBT. Thank you.
We appreciate the testimony that's been given, and both of you are excused. Thank you very much.
Thank you.
I have been approached by the gentleman from Maryland asking that I accommodate him ahead of others who have been seated. So the chairman has made a decision that the gentleman from Maryland would be recognized for the purpose. I know he has to go. Well, I'll make that decision. I still recognize, this is guilt by association, Chris. You're just going to. The gentleman's recognized.
Thank you, and I'll make a proposal to the committee. Make my amendment in order. This will be the last time we'll be at the Rules Committee in a long time. This is.
With the gentleman raised his hand to be sworn.
That's tempting, isn't it?
Gentleman raised his hand to be sworn.
That's right. Okay, so maybe we'll work this out. This is, as you know, the sequester hits on Friday. This is a proposal to replace the sequester with a balanced alternative. And because, Mr. Chairman, I'm not able to stay, I won't say anything more other than to ask unanimous consent that I submit a statement for the record. This is the same amendment that I've proposed before, and third time now, and we hope we can get a vote this time.
Without objection, the gentleman's statement will appear in the record. I want to caution you, you wander in great territory with Mr. Khan, and it made me feel very good to see him up here also. I'm delighted that you took time to come see us. You have friends up here, and we're delighted that you took time. Gentlemen,
thank you, Mr. Chairman.
Thank you.
Thank you, members.
We would now further testimony and would welcome the gentlewoman, the Honorable Gwen Moore from Wisconsin, who represents Financial Services Committee and the people of her district, and she's welcome. Without objection, we'll accept the testimony that you may have written, and we'd appreciate a summary of anything you'd like to give to us. Gentleman's record.
Thank you so much, Mr. Chairman, for that courtesy, and I do think I will avail myself of the opportunity to submit my written comments and not reiterate many of the things that have been said. But I do, I'm here to offer the Senate-passed version of the Violence Against Women Act as an amendment in the nature of a substitute, along with my esteemed colleagues, House Judiciary Committee Ranking Member John Conyers, House Rules Committee Ranking Member Louise Slaughter. Both of them have been longtime leaders on the issue of domestic violence and sexual assault. And also, there's been a request to add Ms. Jackson Lee as a co-sponsor of my amendment as in the nature of a substitute.
That's right.
Also, I do want to thank you, Mr. Chairman, and thank all the members for their courtesy in sitting here. And I do want to particularly thank Mr. Cole and Mr. Issa, who've done remarkable work on trying to reach a compromise, particularly on the tribal provisions. We know that we are not alone, that there are members on the other side of the aisle who do prefer the Senate version of the bill, and that were my amendment to be made in order and allowed to be voted upon, we may have an opportunity to prevail. We know that the Senate version has many champions from all corners of the country and all walks of life. The bill is supported by over 1,300 domestic and sexual assault organizations. And of course, as you know, it provides coverage for immigrant women, Native Americans, LGBT, college women, women who are stalked. And we think that that is what comprehensive means. And again, I won't reiterate all of the concerns and complaints about the House version, which we have worn out here. I just did want to address a couple of the issues that Mr. Gowdy raised. And I am hoping that the constitutional law, Mr. Hastings, I hope that you will help me out. Mr. Cole, I would hope that you would help me out because I'm not a member of the Judiciary Committee. I'm not a constitutional lawyer. I think that when Mr. Gowdy referred to Oliphant, he was talking about a 1978 Supreme Court decision that held that federal laws and policies divested tribes of criminal authority over non-Indians. In 1978, there was very little to no intermarriage and interrelationships with Native women. Of course, times have changed. And so now a majority of Native American women find themselves married to non-Native men. And so this is a provision that has plagued Indian country as women, Native women find themselves victims of domestic violence 2.5 to 3 times as opposed to other women in this country. So it really is a problem. Mr. Gowdy testified, I believe inaccurately, that the House version of the bill covers all women. But the problem that I want to share, and I think Mr. Nugent really pointed it out in his inquiries when he said he doesn't recall a single federal prosecution of domestic violence in a federal court. That is the point. The tribes have no authority over non-Native people on tribal lands. The local police don't have any authority. The county sheriff doesn't have any authority. The state troopers don't have any authority. Only the federal government has authority. And if you're one of the tribes in Wisconsin, for example, I'm thinking of the Bad River Band of Chippewas, their federal court is 500 miles away. So it shouldn't be surprising to us that in 2010, the GAO report found that the U.S. attorneys, and I think Mr. Gowdy mentioned this, declined to prosecute 67% of sexual abuse and related matters that occurred in Indian country. And that this violence is escalated in domestic violence because because men can do it with impunity. In fact, unfortunately, Mr. Chairman, we have heard cases where literally perpetrators have dragged women back onto tribal lands to complete rapes because they know that they could do it with impunity. And we find this to be extremely egregious. And so when we start talking about the constitutionality of this, we really do have to go further than Oliphant. And Mr. Gowdy did mention the court in U.S. versus Lara, which found that Congress has the authority to recognize and affirm the inherent authority of an Indian tribe. The court held that the Constitution confers on Congress plenary power to enact legislation to limit or to relax restrictions on tribal sovereign authority. And that is what the Senate bill asks us to do. It asks us to recognize that this is a gap that is causing, an abnormal increase in violence because it can be done with impunity, and that it is a gap in legal jurisdiction that needs to be held. Now, the bill does recognize the rights of defendants, and defendants have to be given the same constitutional rights as any other defendants. But to recognize the rights of non-Indian defendants, what the Senate bill does say is that the perpetrator has to have sufficient ties to the Indian tribe. They have to be a spouse or a lover, boyfriend, have to work on the tribal land in order to be subject to this native authority. and we have scholars, over 50 scholars, who have said that this is constitutional. And again, he cited Lara, but Lara clearly says that Congress has the right. We can vote to give tribes this authority, and then it would not be found unconstitutional in the court, notwithstanding the fact that we pass not unconstitutional stuff all the time, and it's not unconstitutional unless the court says it does, and if we pass it, the court will say, well, we opined in 2004 that if you give tribal authorities this increased authority, then they got it. So he, with all due respect, he is wrong about that. And of course, I, like him, am not a constitutional scholar, but I would ask you at this time, Mr. Chairman, if I could submit with some modifications this report from the National Congress of American Indian report on the Violence Against Women Act reauthorization, and also a paper on myths around Native American women. I just want to say something about what also seemed to be rather controversial, and that was related to lesbian, gay, bisexual, and transgender women. Mr. Gowdy testified that he had never heard of a woman who had been denied services or housing because she was a lesbian. Well, we have heard of many women who have been denied services because of their status, their sexual orientation. And the advocates and practitioners have, as a result of best practices, Mr. Chairman, have decided that they needed to do that. We're disappointed that the House version just strips all references to sexual orientation or gender identity. However gender neutral we want to be, the reality is that the Violence Against Women Act needs to recognize that lesbians who are still women can become victims at the same rate, or sometimes in many areas at a higher rate than other women. And of course, 94% of perpetrators are men. There was a question raised here earlier, I believe Mr. Woodall raised it, as to whether or not we're ever going to be able to defund or end or deauthorize the Violence Against Women Act. What a great day that will be. What a great day that will be. In these hard budgeting times, with the sequester, which will cost Violence Against Women Act $20 million more, even though we have cut the appropriation for this in this bill by 17% by combining certain programs and eliminating programs and trying to be as efficient as possible. $20 million should the sequester take hold. And 3 women a day die from domestic violence. And when there's no woman or volunteer on the other end of that telephone, there's no shelter that you can go to without someone saying, well, maybe you're a lesbian and we don't want to complicate situations here.
Ms. Moore, that would be against the law. And
well,
just such as
what? I guess they don't have to say it, Mr. Sessions. I don't know. It's
I'd like to interrupt the witness. Is the gentlewoman a lawyer?
No, sir, I'm not.
Is the gentlewoman bringing forth facts of the case, that giving testimony to this committee, that she's aware of this happening?
Yes, I am. I'm aware of women being turned away from shelters, because
of a sexual orientation.
Yes. We are aware of that.
It would be my hope that she would, and I'm not a lawyer, but it would be my hope that someone would contact the Attorney General of the United States under provisions of the law and would receive assurances that that was an improper application of the law.
Mr. Session, I'm not here seeking to prosecute providers who have denied shelter because that's not my purpose of being here. I think that's a dilatory tactic to prevent me from completing my testimony, which I would like to do.
The gentlewoman is for the committee, and I've asked the gentlewoman to please suspend a moment. The gentlewoman is suggesting that the legislation that is before us might be flawed in a way that would not allow full prosecution under some provision. And I asked the gentlewoman, as part of her testimony, if she was aware of this happening, and she said she was. I simply am responding back that it would be my hope that the people who have given testimony, who are lawyers in this case, have told us that would not be a correct application of the law, not that it did not happen. And so I'm simply advising her that we believe in testimony that we've heard here that that would not be a flaw in the testimony, that would be a flaw in the way that it was applied. Gentlewoman may proceed.
Thank you so much, sir. And I do appreciate the empathy that you are showing for these women. I do think that we have seen the complication that advocates in the field experience when they don't have room for whole families that need shelter. A woman shows up with 3 kids, one of them is a teenage boy, and so that creates a complication with respect to placement. And lesbians have the same complications with respect to placement. And so this bill, as a result of recommendations that have been made by advocates or best practices, suggested those provisions because their experience in the field has called for it. I would submit my testimony as written, and I would be very happy to answer questions as the committee so desires.
Thank you very much. Are there questions for the witness? Mr. Cole?
Quickly, my friend may not be a constitutional lawyer, but she sounds like one to me. I appreciate very much how hard you've worked on this issue and what you've done to highlight it. And this is one of those holes in our judicial system where tribal jurisdiction is concerned. My views are probably a lot more expansive, frankly, than this legislation is. And to me, it's common sense at the end of the day, you give local people the ability to take care of their problems. That seems to me preeminently something we ought to be doing. We ought to be empowering people and giving them the authority they need. As you point out, and I'll phrase it perhaps a little bit differently, look, hunters know where to hunt, fishermen know where to fish, predators know where to prey. They know where the legal framework is insufficient to prosecute them. And they do that in a variety of communities. And, when we put an alarm on our house, we don't keep it secret. We put a big sign on there so they know if you come here, it's going to be tougher. And we need to do that in a lot of our communities around this country, but particularly this one where the federal government, frankly, has never come close to providing the law enforcement capability that it's obligated to, the prosecutorial intensity that it's obligated to, and the idea that we would keep tribes from doing for themselves what we are unwilling to do for them. And that's all they're asking for here. Is to me one that just doesn't bear much scrutiny and inspection. So I appreciate very much your testimony and how well you've led and how intently you have pushed this issue. Thank you very much.
Thank you so much, sir.
Thank you. Ms. Slaughter?
I want to add my thanks too, Ms. Moore. You've done an incredible job. This bill that passed the Senate that you are championing here today is so far superior to what we have been living with since 1994. And just reauthorizing because it gets into much more detail and, as Mr. Cole said, really rights wrongs that many times, unfortunately for us, we were not even able to see. We all know that people have been turned away from shelters. We've heard those stories for years, but we have an opportunity now to remedy that. I want so much for all my colleagues on all sides because I know all of you feel the same way, that you don't want to turn away people in pain, that if we just could get the vote so that we could do the Senate bill, pass that and get this over with, because I believe someone also asked what benefit do we see from the bill. The benefit from the bill is what you see now in what happened with law enforcement. As I pointed out, that was one of the great things we wanted to do, was to break the cycle of violence, and we've been able to do that. And we just can't risk losing the gains that we've made by letting this go any longer unauthorized. So thank you so much for all your work. And we want very much, and I plead with my colleagues here, and I know that our chairman is very inclined to do this, that we have an up or down vote on this Senate bill. Thank you very much.
Thank you.
Mr. Woodall.
Thank you, Mr. Chairman. And I don't know, Ms. Moore, if this is within your knowledge of the bill, but I do know you've worked so hard on it. When we talk about adding gender identity to the list of protected categories, I'll ask you to walk me through that to make sure I understand it. If I'm a woman and I show up at my shelter in Gwinnett County, I'll be admitted. If I'm under the Senate bill, if I'm a gay woman and I show up at the shelter in Gwinnett County, I cannot be turned away. Is that your understanding?
You know, I'm not an expert on this area as well, but what I will say is that the practitioners in the field, law enforcement and advocates, see a need to address this such that, for all we know, there may be new vendors that would apply for grants under VAWA because there is a need for those kind of shelters, like the example that I gave before, when a woman shows up running away from a batterer and she's got a teenage son, you don't feel comfortable putting her there with the other bunch of women and babies. So that it might be simple as that. I know that I am from Milwaukee, and our community is still shaking from the Jeffrey Dahmer incident. Jeffrey Dahmer lived about 2 or 3 blocks from my home. And one of the real tragedies in that case related to police authorities coming out and turning one of the victims back over to Jeffrey Dahmer because they believed that this was just a boyfriend thing, and they sort of shrugged it off and laughed it off, even though this man had holes drilled through his head, and he was obviously stunned, and there was, you know, a woman out there arguing with the police, can't you see that something is going very, very wrong? And it might just be a matter of training for police officers, which Violence Against Women Act provides to law enforcement. Law enforcement, as you know, Mr. Woodall, has come a long way. I think you said in your previous queries that there was a time when, you know, cops would just come out there and shuck and jive with the guy and talk about the football score and walk off. So there might be a variety of ways in which the Violence Against Women Act provisions could educate, could provide housing, could address some of the complications of someone, say, a transgender person needing services. It might pay for a position with regard to a culturally competent counselor. So I couldn't anticipate the ways that it would do it, but the advocates feel that this is a necessary area to cover.
Well, just to make sure I understand, the example you used in Jeffrey Dahmer was a man-on-man attack. Your preferred version of the Violence Against Women Act is one that would provide funds to prevent violence against men as well.
Oh, absolutely. There are, again, as my colleague here noted, he said it was 99%. I don't think it's that high. I think it's only about 94%. But there are men who avail themselves of services as well. And it might be a male on male, but the point is the word sexual orientation or gender identity would cover those people as well. And so, again, it's the people who have brought forth, it's been a long time since 1994 when the first Violence Against Women Act, and this legislation has evolved based on best practices. I'll give you an example. In the beginning, nobody really thought about the impact this had on children. There was a lot of focus on getting a woman in the shelter and so on. And what we have found out is that there is a next generation of men and women who become victims and perpetrators based on not having had counseling, that you can't just tend to the victim. Or you can't just counsel the batterer, you have to support the children through it too. And so that has been a program that has evolved from best practices.
Yeah. Well, now 20 years into VAWA, hopefully we're starting to see the benefit of that generational.
I'm going to be, if I live long enough, I would love to be at the banquet when we no longer need it.
Ronald Reagan famously said we declared war on poverty and poverty won. When we declare war on violence, the great hope will be that violence will not.
It involves a great deal of education, which I am glad is part of the funding stream. To let because there are lots of men who believe that raping a woman was just part of their what do you call it? Their what term am I looking for? Rite of passage. And so I think that there needs to be an education around that, and that's one of the things that this bill allows us to do.
I thank the gentlelady.
Thank you for your question.
Mr. Hastings.
Mr. Chairman, I'm fully supportive of Ms. Moore's position. When she began her remarks, she indicated that she would ask Mr. Cole and myself to help her. Like Mr. Cole, I don't think Ms. Moore needs no help. She handles herself extremely well, not only on this issue, but the other dynamics that are important. What her amendment does is augur forcefully for what the Senate did that the House has stripped for pure, unadulterated political reasons. Thank you, Mr. Chair.
Appreciate it, gentlemen. Is there anyone? Mr. Nugent.
Mrs. Moore, I love your passion. I really do.
Thank you.
And as an advocate, particularly as it relates to violence against women, but violence against anybody, and you hit it on the head. I mean, the title of this bill is violence against women, but it is more than just that. And so I appreciate it. One thing I would recommend to you, if you hear from a constituent, and I have served on a board of directors for a domestic violence shelter, and have received funds through the state because it's typically passed from the feds to the state. And the federal government sets out the rules and regulations, particularly as it relates to the treatment of those that come for service. If you become aware of a fact where somebody's discriminated against because of their sexual orientation, that is covered. I would suggest that either you inquire or somebody inquire to make sure that those agencies, their feet are held to the fire because they're accepting dollars from the federal government passed through by the state. And typically the states have mechanisms in place where they come out and audit, but a lot of times it's not the auditing, it's what a person who needs the services needs to speak up. And so as an advocate, you need to advocate for them too, to make sure that those places that are receiving those tax dollars are providing services and not discriminating against anyone, whether it be a male or a family that has a teenager, because there are other ways to deal with those. And having sat on a board, you have the resources to put them up somewhere else if it's a problem within the shelter itself. And so I would advocate for them with either your state organization for domestic violence or also just directly to the U.S. Attorney's Office, or DOJ, actually.
Well, Mr. Nugent, thank you so much for noticing my passion. This means a lot to me, and I, too, abhor violence against anyone, but it is my experience that I hardly know a woman who has not been beaten by a man, raped, a victim of domestic violence. I hardly know a woman. And I'm talking about intergenerationally. This is a disease that plagues women in particular ways. And I've personally known women who've been murdered as a result of domestic violence. I've known women who have been psychologically damaged, and I have personally been a victim and a survivor of rape, domestic violence, of people who claim they loved me, and so on. So I'm very passionate about this. You know, there are no feet and there are no fires to put someone through when they are prejudiced and bigoted against people who are of different sexual orientation. And let's not pretend that many of us didn't laugh and joke about gay people and lesbians, and maybe we've evolved as the president has. But, you know, I was in church just last Sunday in the pulpit talking about lesbians, because I know that might not have made everybody in the church comfortable. And I was also saying, I don't care what you think about lesbians. They do not deserve to be beaten to death. And if we don't have language talking about sexual identity and gender identity in the law, you can't hold, it doesn't have any feet in the law, and you can't hold them to any fire. You know, if I were a defendant who turned down a transgender person, someone who was born a male, at a shelter, you know, you can't say, here's an imaginary provision that you should have taken them in when you've got 5 bedrooms, a small shelter, and, you know, you didn't try to accommodate them. What feet and what fire? And so I am saying that maybe that shelter, I mean, the shelter has a right to say we only take women or we only take single women. But when we don't put this in statute, we're not necessarily allowing grantees to apply who might say we're going to serve this particular population. And I'll give you an example that may or may not seem relevant. Homeless youth. We have found that a huge majority of homeless youth are LGBT youth because their parents kicked them out for being gay and lesbian. And so we have found a need to provide grants or identify grantees that will serve this special population because their own parents reject them. So we know that gay and lesbian people, with all due respect to you, Mr. Nugent, can't advocate for themselves, especially when they're in distress. So I think that the language is very important. It was not offered as a sort of dilatory strategy. It was put in there because law enforcement advocates found that it was another gap in coverage for the bill.
I wasn't talking about language that was in the bill. I was talking about the fact that when you have someone come to you, there are protections in the law that I know are there and that they should be held accountable for what is already in the law. You can add additional language. That in and of itself may or may not solve the problem, but it's already there in regards to when they sign the paper to take the dollars. It's already in the language. So what I was saying to you, it has nothing to do with the language that is or is not in this, substitute, but it is about what already is current law, and to advocate for that, I would strongly suggest that when you hear that, just don't accept it, because as a recipient, when I was a sheriff from the federal government of dollars, trust me, they have ways to make you comply when you take those federal dollars. So I'm just as someone who has been on the receiving end of grants from the federal government, there is a whole host from DOJ in regards to making sure that those grantees follow current law and follow the rules that they agreed to when they take it, because DOJ has laid those out. So,
with your indulgence, Mr. Chairman, I just want to say that you're no longer a sheriff and I'm not an advocate. We're members of Congress, so I'm asking you to, as a member of Congress, to vote to have the language in there so that there's no misunderstanding.
Is there anyone that seeks further time with this witness? I want to thank the gentlewoman for her time before the committee.
Thank you so much, and we will submit those materials with an explanation of the changes that should be
without
reflected.
objection. The testimony that the gentleman would like to enter to the record will be afforded.
Thank you so much, committee.
Gentlewoman's now excused. This ends the hearing for S.47, and Chairman would be in receipt of a motion.
Mr. Chairman, S.47 Violence Against Women Act reauthorization is a structured rule. Provides for 1 hour of debate controlled by majority and minority leaders or their designees. It also makes in order an alternative amendment consisting of the text of the Rules Committee, print 113-2, debatable for 20 minutes. Finally, the rule provides for a motion to commit.
Gentlemen, suspend a moment, please. I apologize. I need to be in receipt of a motion, and the gentleman from Utah was not yet there, and I'm sorry. And I do intend, as this committee understands, to recognize the gentleman in that explanation. I would be in receipt of a motion from the gentleman from Utah then.
Don't steal my thunder again here.
My apologies.
Mr. Chairman, I move the committee grant S.47, the Violence Against Women Reauthorization Act of 2013, a structured rule. The rule provides for 1 hour of debate equally divided and controlled by the majority leader, the minority leader, or their respective designees. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against the provisions in the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of the Rules Committee, print 113-2, if offered by the majority leader or his designee, which shall be in order without intervention of any point of order, shall be considered as read and shall be separately debatable for 20 minutes, equally divided and controlled by the proponent and opponent. Finally, the rule provides for one motion to recommit with or without instructions.
Thank you very much. We've now heard the motion that has been made by the gentleman. The gentleman now would be recognized for an explanation of the rule. The gentleman, Mr. Nugent, is recognized.
My apologies, Mr. Chairman, for jumping ahead. And I'm glad.
Gentleman's recognized.
Thank you, sir. Once again, the Senate Bill 47, Violence Against Women Act reauthorization is a structured rule. It provides for 1 hour debate controlled by the majority and minority leaders and their designee. And it also makes in order the alternative amendment consisting of the text of the Rules Committee, print 113-2, debatable for 20 minutes. Finally, the rule provides for a motion to commit. Clearly, there's strong feelings on both sides of this issue. And this rule will allow the House to work its will and decide between the two alternatives, which I think is a great way to move forward to allow the House will to be acted upon. Thank you, Mr. Chairman.
I thank the gentleman for his explanation. Is there further motion? Gentleman's recognized.
I'd like to be recognized, if I may, on this. It's terribly important that we do get an up or down vote on the Senate bill. As I understand this, you will bring up the Senate bill, substitute the House bill. If that House bill fails, there will be a vote on the Senate bill. Is that correct? An up or down vote on the Senate bill?
And then the
As
House
passed
will
the
be as a
Senate.
substitute, right.
All right. Our most important thing for us is to make certain that we have that right to that vote. So I would still like to do an amendment to make this
And if I
more in
could
order.
interrupt the gentlewoman.
Sure.
I think it is the intent of this committee to make sure that a bill passes as a result of the votes on the floor of the House of Representatives.
Well, a bill could pass, but that doesn't mean that the Senate bill would have a vote.
Well, what I'm suggesting to you is the will of the House, I believe, will be given the opportunity, which I believe you would have every opportunity to pass that Senate bill.
If you're saying what I think you're saying that yours is going to fail, and we can get right down to it. Why don't we just get down to it in the first place?
You know what? I do respectfully appreciate that. What I'm suggesting to you is, yes, I believe you're correct, and I believe that the intent of this committee is to
pass the Senate bill.
Is to pass a bill out of this House.
Well,
and I think we'll do that.
Well, I'm sure we would
we
be
can all
up here
guess
spending
what
all
might
that time.
happen.
We didn't intend to pass a bill out of this House. My concern then is that making certain that the Senate bill, which we are purporting to be using here, gets an up or down vote. And perhaps the best way I can do that is to try to have this more made in order.
Wish to make a motion?
All right, and I shall do that. Because of the importance of it, and this bill has always been bipartisan. I want to plead to my colleagues here, let's don't change that. It's lives have been saved and things have been changed. And for the first time, I think since I've been here, I really feel good that we're doing something for the Native American women who did so much for us. I won't get into that, but I'd like to talk to Mr. Cole about it. But in any case, I do have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment by Representative Moore of Wisconsin, number 5, which I am pleased to co-sponsor. This amendment is the real Violence Against Women authorization. It is the bipartisan bill that passed the Senate with a vote of 78 to 22 on February 12th. And unlike the House Republican bill, it does not roll back protection for victims of domestic violence. So I ask you, please give members a choice. We've been kicking this football around this town for such a long time, and we don't look very good for that. And I know that all of you on this committee feel the same way I do about it. When people are in pain and hurting, we want to help. So I'm going to ask you, please, to give a chance to Ms. Moore to put her amendment in order and to have a vote for it.
Gentlewoman is asking for the amendment to be recognized and voted on, and I would encourage a no vote. Those in favor of the amendment by the gentlewoman signify by saying aye.
Aye.
Those no?
No.
Roll call.
Gentlewoman asks for a roll call vote. Clerk will.
Ms. Fox. Mr. Bishop. Mr. Bishop, no. Mr. Cole. Mr. Woodall.
Could I ask a point of order, Mr. Chairman? Is that appropriate? This
gentleman may ask.
Parliamentary inquiry.
Point of parliamentary.
This is a vote on whether or not to allow an amendment that would replace the underlying text with the exact same language that's already in the underlying text?
It is my understanding that would be correct.
No, it isn't. It would allow you to replace the underlying text with the bill that passed the Senate 78 to 22.
I believe that is what the gentleman just said.
That's what Ms. Moore's amendment does, is replace it.
The underlying bill is the language that passed the Senate, and this is an amendment to replace that language with exactly the same language?
It would make sure that we get a vote on the Senate.
With the language.
Exactly the same language.
It's my understanding the gentlewoman's.
I thank the chairman. I'll have to be a no.
Mr. Woodall, no. Mr. Nugent. Mr. Nugent, no. Mr. Webster. Mr. Webster, no. Ms. Ross-Laitman. Mr. Burgess. No. Mr. Burgess, no. Ms. Slaughter.
Aye.
Ms. Slaughter, aye. Mr. McGovern. Mr. Hastings. Mr. Hastings, aye. Mr. Polis. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report.
2 yeas, 7 nays.
Mr. Chairman.
And
one pass.
6 nays.
Amendment is not agreed to. Further discussion or amendment?
Yes, Mr. Chairman. Mr. Chairman, I've been on this committee a long time with you, both in the majority and in the minority, and I've seen any number of measures offered by either majority, Democrats or Republicans. But I know that this has happened before. I don't remember whether it was on mine and your watch, but clearly it's evident that the House majority doesn't have great confidence in the measure as offered. And I do accept that your position is that it will allow, once your measure fails, that the Senate measure at least will be voted on up or down. I have an amendment to the rule, and I move the committee make an order and give the necessary waivers for the amendment by Representative Van Hollen, number 1, which would replace the entire sequester for 2013 with savings from specific policies that reflect a balanced approach to deficit reduction. It also protects our most vulnerable citizens by asking those who earn over $1 million per year to contribute more, and it eliminates agriculture direct payments and cuts subsidies for large oil companies. An additional comment I'd like to make, Mr. Chairman. We name things around here, and I don't know how it got, there's debate back and forth, and now it has become the Obama sequester. But if there was ever a misuse of a word for a set of circumstances, then the use of the word sequester having to do with the kinds of cuts that America is likely to experience in the next 3 days. And there are only 3 legislative days, and that's why I believe Mr. Van Hollen, who has brought this measure here the 3rd time, has done so again. This is a vehicle that's leaving Congress, and it would be helpful if we acted now and replaced the across-the-board spending cuts that have already created much pain and uncertainty, not only for the middle class, but for all Americans. The Republicans, my friends in the majority, have had many opportunities to put forth a plan to avoid this thing called sequester, but haven't acted on one during this Congress. As I pointed out, this is the 3rd time Mr. Van Hollen has submitted his amendment to the Rules Committee in the 113th Congress, and I don't think we can wait any longer. Now is not the time for whatever we call this thing. We know it's going to be harmful, and both sides may get something, both sides may get nothing. But it's the time for smart government solutions. And this amendment puts a balanced approach on the table, and it is time to work together for the sake of the American people and responsibly strengthen the middle class as we work to reduce the deficit. This is our opportunity to do just that. I'm fearful that we won't, and I'm shuddering at what is likely to happen in our economy. And I'm hopeful that before the continuing resolution, that some of us come to our senses and deal with the realities that this nation is confronted with, and that some of us stand up and tell the American public that, yes, we are going to have to address every angle of the budget in an effort to put our house in order. This is a great country, and we shouldn't be doing ourselves this way, and that goes double for both sides from my point of view.
Would the gentleman yield?
Of course I will.
Is the amendment that you're asking the committee to make in order one that's going to strike all of the language that we've been discussing about the Violence Against Women's Act? I mean, I know we had some disagreements about what some definitions would be, but I thought there was unanimous agreement on this committee that we wanted to extend the Violence Against Women's Act, and that it had been tremendously effective and that it would be tremendously effective going forward. But my reading of this amendment is that it would eliminate every word of the Violence Against Women's Act and put that issue off yet again. Is that the gentleman's understanding?
Better to put that off, and yes, that is true. Better to put that off than to allow the sequester to hit, and we can take it up in its proper form. But this amendment, yes, would ask that we consider trying to do what is necessary to avoid the sequester.
I thank the gentleman.
The gentleman is appreciated and respected for his amendment. In discussion of this, I do note that the gentleman, Mr. Van Hollen, did approach the committee several other times. I did allow him to be here tonight with respect to his ideas of the piece of legislation that we were handling and his agreement that he would come to the committee. I'm sorry he did not have time to be with us, and he did ask that this would be done. Well, there may be truth in that also, and I appreciate it, gentlemen. Chair would respect this motion, this amendment, and ask for a no vote. Clerk will, all those in favor of the amendment signify by saying aye. Aye. Those opposed, no. Then no. Roll call vote. Clerk will report.
Ms. Fox. Mr. Bishop. No. Mr. Bishop, no. Mr. Cole. Mr. Cole, no. Mr. Woodall. Mr. Woodall, no. Mr. Nugent. No. Mr. Nugent, no. Mr. Webster. Mr. Webster, no. Ms. Ross-Lehtinen. Mr. Burgess. No. Mr. Burgess, no. Ms. Slaughter. Ms. Slaughter, aye. Mr. McGovern. Mr. Hastings. Mr. Hastings, aye. Mr. Polis. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the vote.
2 yeas, 7 nays.
The amendment is not accepted. Are there further discussion or amendments to the motion that's on the floor? All those.
Mr. Chairman, may I? Just in terms of discussion, thank you, Mr. Chairman. In terms of discussion on the bill, number one, I appreciate very much how well you've worked this, because I know your intent is that the House have the opportunity to consider both these measures. And I want to reassure my friends on the other side, I would have certainly pressed my amendment had I not believed we would have this kind of vote. I have no assurances, but I believe we will. And I want my friends to know I certainly will be voting with them. And that means I have to not support the Republican alternative so that we do get to your vote. And the only reason I do that is because of the tribal provisions, or the main reason. But again, I think there's been a really good faith effort by all concerned in this issue. We've come a long way. I appreciate what the majority leader and the authors of the Republican bill did. I appreciate very much what the Senate did. Still think our amendment was a little better. But I think we'll have a good opportunity and a good debate. And so thank you again for giving me the opportunity to go on the record. And I look forward to working with my good friends, and hopefully we can make a step in the right direction on a variety of fronts, but particularly in terms of enhancing jurisdiction and of tribal communities over their own territory. Yield back.
I appreciate the gentleman's comments. In fact, I believe the gentleman, Mr. Cole, and others at the table have spent a great deal of time not only working with leadership on both sides of the aisle on this issue, looking at very carefully the Senate bill, determining a position that might be taken by the House. And in my opinion, I attempted to position this committee as an open arbiter that would be fair, allow anyone that chose to come to us today to present testimony. And I believe we had expert witness testimony, not only from the Judiciary Committee, but a lot of other people who came to give us their own advice also. So I find myself in a position of trying to get my job done as the committee chairman, trying to make sure I can look at every member of this community, committee that we have here and the communities that we represent. And I appreciate what Mr. Cole has done as an advocate throughout this entire process of trying to work carefully and fairly in that process. Is there further discussion? The motion is now on the floor of the gentleman from Utah. Those in favor will signify by saying aye. Aye. Those opposed, no. The motion carries. The gentleman from Florida will be carrying the bill on the floor for Republicans. And the gentlewoman who was an original co-sponsor and helped write the bill some 20 years ago will be on the floor with that reauthorization. We do not expect any further meetings this week, and I want to thank everybody for their time. The committee is now